Welcome to the Insurance Agents and Brokers Podcast.
Hello, and welcome to the audio version of Claire-ification. Claire-ification is a monthly guidance column in IA&B's primary agent magazine and is written by Claire Pantaloni, IA&B's Vice President of Advocacy. The question posed for the May 2026 column is, while transitioning paper files from a purchase agency into our management system, I discovered some enforced policies without signed applications. How should I handle this? And the answer is, unfortunately, it is not unusual to discover missing signed applications when transitioning files from a purchase agency, or even during a routine internal audit. As uncomfortable as it may be, it's far better than discovering them after a claim occurs. Signed applications and required selection forms such as UM/UIM and stacking forms in Pennsylvania document the insured's coverage choices and representations. Most carrier agreements place responsibility for maintaining these documents squarely on the agency. If they can't be produced at claim time, the carrier will likely pay the loss and pursue recovery through your E&O coverage. So, how to handle it? If the policy is recent, for business written in the current term, the fix is usually straightforward. Contact the insured, explain that an audit revealed a missing signature, and obtain a properly dated signature, never backdate. If a policy was written years ago, start with the carrier. Contact each affected carrier. Insurer procedures vary, and some carriers may have more flexibility than others. Some may be less concerned with the application than they are with the missing statutory forms, such as tort, UM/UIM, or stacking, because unsigned forms can default to higher limits by operation of law. Keep tabs on each carrier's recommendations. At renewal, prioritize the accounts with missing signatures for a thorough coverage review. Any changes or remarketing will generate new applications and selection forms, giving you a clean path forward for those accounts. If the renewal review does not yield any changes, as mentioned above, each carrier may handle this situation differently, and you will need to follow their guidance. If you cannot recreate the application, one carrier may ask you to focus your attention on securing signatures for any required statutory forms, including UM/UIM, tort election, and stacking. Another carrier may ask you to also secure a written affirmation from the insured, confirming the insured's current coverages and limits. While not a substitute for a properly executed original application, and not a guarantee against E&O exposure, it may help document the insured's intent. Yet another carrier may prefer that the insured complete, date, and sign a current accord application with today's information, which could be retained by the agency in case of claim. In all those cases, it is best to follow the specific carrier's instructions. Preventive measures. In the case of an agency or book purchase, keep in mind that the agency should always do a thorough review of all accounts that are being acquired. In addition, moving forward, this incident is a good opportunity to set new processes, including reinforcing staff training. Confirming signature verification is built into system workflows, reviewing documentation retention procedures, conducting periodic spot audits, and finally, addressing the issue proactively can significantly reduce future E&O risk. Thank you for listening.
Insurance Agents and Brokers is the premier resource and champion for independent insurance agencies in Pennsylvania, Maryland, and Delaware. For more information, visit iabforme.com.
This is not a legal opinion and should not be relied upon as such. The intent is to provide a general background regarding the topic or topics discussed, not to provide legal advice. Producers and agencies should consult an attorney regarding specific situations and specific questions with respect to the topic or topics covered. Neither IA&B nor any of its employees shall be responsible for any errors or omissions regarding any statements made, nor any errors or omissions regarding any statutes, regulations, court rules, and/or any other government documents cited.